Hey there, if you're a creative, you've probably asked yourself this question. Should I copyright my work? Well, the answer is absolutely, but maybe not for the reason you think. Let me explain. Should I copyright my work? Well, of course, but really that's not the right question. Let's rephrase that. Because you don't actually have to do anything to copyright your work except create the work. The moment you've taken your idea and reduced it to some tangible form of expression, photograph, piece of art, music, whatever that is, you own the copyright in that work. It is already there. The question you're really asking is, should I register the copyright of my work? And that's what we want to talk about. So if all you really do as a creative is do work for hire for others, the copyright is always going to be owned in your client's hands or whomever, then probably not. But if you intend to make any money off of your work, license it, sell it, distribute it, perhaps just keep others from stealing it, well then registration is a must. For several reasons. First, you cannot sue anybody for copyright infringement without a copyright registration. It is an absolute requirement to get into federal court to sue for copyright registration. So if you have any desire ever to keep people from infringing, you're going to need a registration. Secondly, it's really easy. It's a very simple process. You can go on copyright.gov. You can do it yourself or a lawyer can help you, but it's a really pretty simple process and it's very inexpensive. Range from $35 to $55 for a standard registration. Now it can take a while. It can take anywhere from 2 months to sometimes up to 12 or 18 months to get the registration. And if you need to sue somebody for infringement right away, you can't wait that long. So the Copyright Office does have a process whereby you can get an expedited registration in about a week's time, but it costs about $800. Now that may be worth it to you if you need to sue somebody and there's real money at stake, but otherwise getting into a regular process of filing registrations on a standard basis probably work just fine for you. Number 3, there's another important reason to register. If you ever have any possibility that you may have infringers in the future, the most important thing you can do is get your registrations in right when you create the materials. Because under the Copyright Act, if you file your registration paperwork, your application for a registration, within 3 months of the date that you publish your work, and by publish I mean simply putting it out into the world. It could be putting it up on your website, distributing to others. If you file the registration within 3 months of that date, then if you ever have to sue somebody for infringement, you can get what's called statutory damages, and you can get your attorney's fees. You won't have to prove that the infringer made any money. You won't have to prove that you lost any money. You'll simply be able to get between $750,000 and $30,000 for each act of infringement. And if they're really bad guys and it's willful infringement, you can get up to $150,000. Plus you can get your attorney's fees. It makes it very, very powerful when you send that demand letter to them, and that's all you have to prove is that they took your work and then you're going to get some amount of money. The only question is how much. Now don't worry if you didn't get your registration in during that 3-month window. You can still file a registration later for a work you created years ago. And you get your registration and then you can sue. But in that case you're going to have to prove either that you lost money, perhaps there's licensing fees that should have come to you, or that the infringer of your work made a lot of money from that infringement and you can attack their profits. So the registration is valuable either way, but if you can get it going out of the box, get on a regular pattern of within every 3 months at least of filing registrations, you set yourself up in a really powerful way to protect your work. There's another reason completely separate from suing for infringement where registrations can have real value, and that is under the Digital Millennium Copyright Act, the DMCA. You may be familiar if you see your work on YouTube or someplace and somebody on a Facebook page or someplace on an internet provider or a platform where your work is being infringed, you can use what's called a notice and takedown provision and send notice to YouTube, to Facebook, wherever that there's infringing work. If you have a copyright registration, it's real easy. They're going to take that work down immediately and let the other person fight with you. If you don't have a copyright registration, you can still get the work taken down, but you may have to provide more proof that you're actually the copyright owner. And if it turns out that that proof is not as solid as you thought, then you're at risk of getting countersued for filing a false takedown notice. So if you've got a registration in hand under the DMCA, you can get your infringing work taken down right away, and you can sue for infringement. Without a registration, you can't sue for infringement at all, and you may find it harder under the DMCA. So, my advice, yes, you should copyright your work. Actually, you should register the copyright that you already own. Take care and good luck.